Hi guys, welcome to today's session, and today we are going to discuss about contempt of court. It's a particular topic which often comes in the news also. So in this session, we'll first see what is contempt, and then we'll discuss why courts need contempt powers, and finally we discuss what are the arguments against the contempt of court and what are the arguments in favor for the contempt of court. So this is how I plan this session. Let's now start. So friends, first of all, what is contempt? The contempt of court law is one of the most controversial elements in the Indian legal context. The basic idea of a contempt law is to punish those who do not respect the orders of the court. But in the Indian context, contempt is also used to punish speech that lowers the dignity of the court and interferes with the administration of justice. And it can be divided into two kinds. The first one is civil contempt, that is willful disobedience of a court order or judgment or willful breach of an undertaking given to a court. And second one is criminal contempt, that is written or spoken words or any act that scandalizes the court or lowers its authority or prejudices or interferes with the due course of a judicial proceeding or interferes or obstructs the administration of justice. So this is the basic idea of contempt. And Article 129 and 215 of the Indian Constitution empowers the Supreme Court and High Court respectively to punish people of their respective contempt. And also the Section 10 of Contempt of Courts Act 1971 defines the power of High Court to punish contempts of its subordinate courts. And the Constitution also includes contempt of court as a reasonable restriction to the freedom of speech and expression under Article 19, along with elements like public order and defamation. So this is basic idea about contempt of court in India. Now we'll discuss why courts need contempt powers. The contempt powers are needed for courts to ensure their orders are implemented and also to sustain the independent nature of judiciary itself. And while the judiciary issues order, they are implemented by the government or private parties. And if the courts are unable to enforce their orders, the rule of law itself will come to a grinding halt. So for these all reasons, contempt powers are needed for the court. But there are many issues with the contempt law. Article 91A of Constitution gives right to freedom of speech and expression to all citizens, while contempt provisions curb people's freedom to speak against courts functioning. And the law is very subjective, which might be used by the judiciary arbitrarily to suppress their criticism by the public. So there are many issues are there. Anyways, we'll now discuss what are the arguments against this contempt of law. The first one is it is against civil liberties. A law of criminal contempt gets in conflict with India's democratic system, which recognizes freedom of speech and expression as a fundamental right. So in this manner, the judiciary draws resemblance with the executive in using laws for a chilling effect on freedom of speech. And former Justice of Supreme Court V.R. Krishna Iyer famously termed the law of contempt as having a vague and wandering jurisdiction with uncertain boundaries. Contempt law, regardless of public good, may unwittingly trample upon civil liberties. And the scope of contempt is wide. That is the second issue. The definition of a criminal contempt in India is extremely wide and can be easily invoked. Also, suo motu powers of court to initiate such proceedings only serve to complicate matters. And further, the Contempt of Courts Act was amended in 2006 to add truth and good faith as valid defenses for contempt, but they are seldom entertained by the judiciary. And another argument against is international disuse of contempt doctrine. Already contempt has practically become absolute in foreign democracies, with jurisdiction recognizing that it is an archaic law. For example, England abolished the offense of scandalizing the court in 2013, And also Canada ties its test for contempt to real, substantial and immediate dangers to the administration. And American courts also no longer use the law of contempt in response to comments on judges or legal matters. So these are arguments against contempt law. And now, guys, we'll discuss what are the arguments in favor of contempt of court. The first argument in favor is high number of contempt cases. There still exists a high number of civil and criminal contempt cases pending in various high courts and Supreme Court. And the high number of cases justifies the continuing relevance of contempt of court law. And second point is it affects judiciary's reputation. Amendment in definition of contempt may reduce the overall impact of the law and lessen the respect that people have for courts and their authority and functioning. And also by abolishing the offense in India would leave a legislative gap. And the next point is constitutional source of contempt power. Supreme Court and High Court derive their contempt powers from the Constitution, and the Contempt of Court Act 1971 Act only outlines the procedure in relation to investigation and punishment for contempt. Therefore, the deletion of offense from the Act will not impact the inherent constitutional powers of the Superior Court to punish anyone for its contempt. These powers will continue to remain independent of 1971 Act. And next point is impact on subordinate courts. Constitution allows superior courts to punish for their contempt. The Contempt of Court Act additionally allows High Court to punish for contempt of subordinate courts. So please remember this point. It is High Court which has authority to punish for contempt of subordinate courts. Now, thus, if the definition of contempt is removed, subordinate court will suffer as there will be no remedy to address the cases of their contempt. And next point is adequate safeguards. The Commission noted that there are several safeguards built into the Act to protect against its misuse. For instance, Act contains provisions which lay down cases that do not amount to contempt and cases where contempt is not punishable. So these provisions suggest that courts will not prosecute all cases of contempt. So these are arguments in favor of contempt of court law. It is a controversial issue and always comes in the news. And recently also the Prashant Bhushan case was there. So it's a very important topic with regard to mains preparation. So please study about this, guys, and we'll meet tomorrow with another topic. Thank you for watching this lesson.